Mr. Hall.
My lords, as you know, I represent the appellant today. My learned friend Mr. Wilson of King's Counsel represents the respondent. Can I just check what your lordships have by way of bundles, please? You should have.
I suspect I've got all the bundles. I'm not necessarily sure that my lord has.
They are here, but they're not
see.
been clocked.
Your lordships should have a core bundle of 198 pages, a supplemental bundle of 171, and then two application bundles. One which is referred to by myself and learned friend as the June application bundle, and another which is the December application bundle. Your lordship should also have an authorities bundle, stretching to some couple of hundred pages. And I hope your lordships have seen some skeleton arguments, some additional skeleton arguments, myself and learned friend on the application.
I personally have. I don't know if my lord has.
I haven't seen those, at least not that I can recognise.
There's nothing actually between us on the application.
No.
And I was going to ask your lordships first whether you would like to deal with the applications first. Before we do.
I think our position is that we'll look at the evidence day by day essay. We quite see that between the two of you, you're content to let in all the evidence. But I don't think we'll spend time ruling on that now. We'll look at the evidence day by day essay so far as anybody thinks we need to.
Very great.
But if you could provide copies of the skeleton arguments over the lunch hour, they haven't got to me, I'm afraid.
Well, I apologise for that, my lord, and yes, we will do.
No, I haven't seen those either, although I have seen the application bundle and therefore did understand your respective positions.
I'm very grateful.
One consequential point, when I originally gave permission, I estimated this at 1.5 days, and then one or both sides said, shouldn't it be 2 days? I think with the new evidence in mind, possibly. Now, you've got a 2-day time estimate, but if the parties were able to complete within 1.5 days, then that's so much the better.
I'm very grateful, and given your lordship's comments already on the applications, I'm sure we can complete within a day and a half. I rather doubt we can complete the appeal today.
No, I'm not suggesting you should, but if we finish by lunchtime tomorrow, then that would be nice.
Yes, my lord. In which case I'll open the appeal. I'm so sorry, there is one more matter of housekeeping. My apologies for this. There was one piece of legislation that was missing from the authorities bundle. My learned friend and I think it should be in there.
Yep.
May I hand that up, please, with
Yes.
an amended index? It's section 14B of the Limitation Act.
Yes.
We're not going to make much reference to it, but for completeness. We think it should be in there.
That's the long stuff, is it?
It is indeed. Each of those contains an amended index and paginated additional pages to go into tab 2 in the authorities bundle. I apologise for that not being there originally. My lord, yes. So this is an appeal against the decision of His Honour Judge Russell, sitting as a High Court judge in Bristol, as embodied in his judgment of 1st of October 2024, which your lordships have no doubt seen the transcript of, which can be found at tab 5 of the court bundle, which led to an order in February 2025, which is the order under appeal at tab 4. Permission to appeal was granted by your lordship in April of last year, at tab 10. And this appeal concerns Section 14A Limitation Act, both as to its interpretation and its application to the facts of this case. And for that reason, because the facts are important, I'm going to have to take you through some of the evidence, I'm afraid. It will take a little time, subject to your lordships being content with that, of course. Before I get to the grounds of appeal, it may help just to very briefly open what the case was about. Your lordships, I hope you've seen this as a professional negligence claim by my client, Miss Kay. It may not be, in fact, apparent from my skeleton, I can't remember, I confess, but she, at the time, the events in question, was called Helen Marn on the Harm. Back in 2007, and at that time she was going through a process of divorce from her then husband, Anil Mahar. She was initially represented by a firm called Manches from London, and then in December 2007 she instructed the defendants, in this case Martineau Johnson, as they then were firm solicitors in Birmingham, the partner with conduct there being Mrs. Mary Kay, who you will have seen a statement from in the bundle. So I will return to the facts in more detail as we go along through the evidence, if I may. But in very brief summary, December 2007, the respondent was instructed. There was an initial meeting on the 12th of December 2007 between the appellant and Mrs. Kay, in which some advice was given. There was a first hearing in what was the ancillary relief proceedings in which the respondent was instructed on the 14th of December 2007, and that was a first directions appointment for Deputy District Judge Jolly, and the matter then went off in the usual course of such an application for first a financial dispute resolution hearing, which later took place in April 2008, and then ultimately would have gone to a trial of that ancillary relief application if necessary. In between the first directions appointments in December 2007 and the FDR, as it's known, in April 2008, there was a series of steps taken by parties. Advice was given on several occasions by the respondent, both in writing and orally at meetings, and they prepared themselves for what's described in family lawyer circles as the FDR on the 25th of April 2008. And those steps that were taken included consideration of looking into Mr. Mahan's assets, because my client, the appellant, was concerned at the outset that he might try and hide his assets. He was a financial advisor, he had a close-knit family, and she was concerned that he might be hiding assets both here and abroad, possibly by his family connections, and had asked Manches to look into that, and they had produced a circa 500-page bundle of documents known as a Hildebrand bundle. And I hope your lordships have seen from my skeleton argument what that is. That's a form of, named after the case of Hildebrand, family jurisdiction, evidence obtained by illicit means that could nevertheless at that point be used in court in ancillary relief proceedings, at least for limited purposes. And so that bundle was provided upon the instruction of the respondent in December 2007, and there was this initial meeting on the 12th of December, which that was talked about and other matters were talked about, which we'll come back to. And then there was advice given, as I say, and including consideration of further investigation of Mr. Mahan's assets, consideration of what's known as an avoidance of disposition order under Section 37 of the Matrimonial Causes Act 1973, which is, as your lordships will know, the statute providing the jurisdiction to grant ancillary relief to a divorcing party, as well as consideration of pension arrangements, and as part and parcel of any such considerations, maintenance would of course be considered. And your lordships would have seen from the grounds of appeal and from the skeleton arguments that one of the key facets of this case is whether or not advice should have been given on what's called a nominal spousal maintenance order, or an NSMO. Such an order can be for £0, in fact, but for a very nominal amount, which will then enable the receiving party under that maintenance order to return to court in the future should circumstances change and seek greater ongoing maintenance provision from their ex-spouse. And as I say, that is a central facet of this case and of this appeal. This advice was not given on the availability of such a remedy, let alone the merit in seeking it.
I mean, are such orders available just for the asking? Presumably not.
The evidence at trial of Mrs. Kay, for the respondent, a little confusing because there are two Miss K's involved here. This is Mary K. I'll call her Mary K for simplicity. Of Mary K was that it would be likely to be ordered at a contested hearing if the matter got that far, as a matter of course. So, yes, my lord, the answer is not entirely as of asking, not an entitlement as of right to such an order, but they were frequently made in circumstances where there was an ongoing potential need for maintenance and the possibility that circumstances may change in the future. Of course, it's a separate matter as to whether or not had the matter, and the matter did progress to a settlement on the 25th of April 2008, but it's a separate matter as to whether or not had some other settlement been agreed on the basis of what we would say would have been non-negligent advice, whether that settlement would have included a nominal spousal maintenance order. So there are two counterfactuals in the underlying professional negligence claim. One is that properly advised, my client would have agreed a different settlement with her ex-husband. The other is, if that was not possible, she would have proceeded to a contested hearing. And she says that in either of those scenarios, she would have obtained a nominal spousal maintenance order if properly advised. Your Lordships may have seen in the papers, and we can, I'm sure, take to references as necessary, but and my learned friend will no doubt address you on this, but there was a suggestion, as at late 2007, early 2008, that Mr. Mahan was in fact riddled with debt, and that he did not have the means then to pay significant maintenance. And if that were correct, then that might, of course, one supposes, put him off agreeing to any form of ongoing maintenance, but it also might mean, and I'm hypothesising here, that in fact there was no harm in him agreeing to such an order, because he was portraying the situation as if he was not likely to have much in the way of assets going forwards against which such an order might, as it were, be enforced. So those were the matters under consideration during the course of the period December 2007 to April 2008. In April 2008, there was the FDR, as I said, 25th of April 2008, before District Judge Ingram, as she then was. And prior to that hearing, there was the usual exchange of offers between the parties and there were negotiations. And your Lordships may be familiar with the process, but an FDR involves a form of dispute resolution, as the name suggests, facilitated by the judge in question, who will then not be able to sit at any final contested hearing. And so the process is the parties negotiate, go into court, speak to the judge gives the parties his or her view. And on this occasion, as we'll come back to, District Judge Ingram described my client's then offer as pie in the sky, gave a strong indication to the parties that she thought my client was asking for too much. And the appellant's case is that combined with further advice given by Mary Kay at the court on that day led to settlement. A settlement in which she was to be paid a £4,000 lump sum of maintenance. She was to get proceeds of sale of the full matrimonial home, but which was mortgaged, and she was given an interest in a claim against a firm of builders called JLB, as well as ongoing maintenance for the two children of the marriage, who were at that time, I forget their precise ages, but certainly both under 12.
6 and 8.
I'm very grateful to my friend, they were 6 and 8 at the time. And in fact, as we'll come on to later in the chronology, in around 2018, one of them was going through A-level exams and the other was dealing with their GCSE exams. So that's the sort of age these children were. There was an ongoing need for maintenance for them. So that settlement was done in principle, but there was a need for the divorce itself to be finalised and approved by the court, and that led to some delay until September 2008, when the order was in fact sealed and approved formally by the courts, which incorporated that settlement. And again, just briefly, there is then a relevant period of events following that.
Is the settlement enforceable when it's entered into, or does it only become enforceable when the divorce is granted?
My understanding, my lord, is it only became enforceable in or
September
after
2008.
Indeed.
Not April 2008.
Indeed, my lord.
Thank
Yes.
you.
Nothing changed between those dates.
Well, she saw the Porsche and he started a company, but...
Well, my lord, in fact, the Porsche and the company came about after September 2008.
Or after September
Just
2008,
after.
okay. Right.
So the next key date in the chronology is the 20th of October 2008, so only some 3 weeks after the order is approved by the court. And as I understand it, as I say, it's at that point in the preceding couple of weeks that she sees the Porsche, learns about the company. There's also an issue about an insurance policy. And she then gets back in contact with the respondent. And there is a series of communications, telephone calls, a letter in November 2008, stretching all the way through until May 2009, which is going to be a critical period that we'll need to examine, where the respondent gives further advice to the appellant about the prospects of reopening the settlement. These early signs of potentially greater wealth of Mr. Mahan having been noticed. What I will say is that, and this is in relation to grounds 1 to 4 in the appeal, is that advice did not trigger actual knowledge for the purpose of Section 14A of the Limitation Act, and indeed that my client, the appellant, is entitled to rely on that advice in relying on the proviso at Section 14A(10) of the Limitation Act as to constructive knowledge. The matter then rested as at around June 2009 when the respondent was disinstructed, and there's no dispute about why the respondent was disinstructed. There was simply nothing further for the respondent to do.
It's not suggested, is it, that the advice that the settlement could not be reopened was wrong? That was right advice.
Indeed.
But your client's case is that she shouldn't have been in that position in the first place.
Indeed. And in fact, that advice was effectively much later confirmed by the advice of Victoria Edmonds, a barrister at St Philip's Chambers, who in May 2020 advised my client in writing that even then, with the, albeit that of course was far later, with the apparent evidence of much greater wealth and success of Mr. Mahan in the intervening period, that this was all post-settlement developments that could not be used to reopen the divorce settlement. So Mrs. Mary Kay's advice, yes, was on the face of it correct at that point, and was echoed much later by counsel. And of course, it's that May 2020 advice which the appellant says is the trigger for her actual knowledge of the attributability of the damage that she had suffered, which is to say, actually the under-settlement of her ancillary relief application, to the act or omission of the respondent, which is the second relevant component here of knowledge required under Section 14A for time to start running. So there's then a period where nothing much happens until around 2017, when the appellant begins to notice further evidence of wealth of Mr. Mahan, such as expensive cars and so on, and coincidentally, towards the end of 2017, begins a relationship with Mr. Morgan, who is a solicitor and who was handling an entirely separate matter for her, the appellant's parents. It has nothing to do with this case, but that's how they came to meet. And as a result of their relationship developing, he agreed to help her look into the possibility of reopening the divorce settlement, having discovered this evidence of further wealth of Mr. Mahan. And the first step in that was seeking a copy of the file from the respondent, which was done March, April 2018. That was when the requests were made. The file was provided in May 2018. Mr. Morgan then, who is not a family law specialist, commercial litigator, then looks at the file eventually, and by January 2019 has realised that there is a document missing from the file called the Form E, which is the form which divorcing parties in an ancillary relief application fill in to give disclosure, at least initial disclosure, of their assets and liabilities. So he then, and indeed the appellant then asked the respondent for copies of the Form E, which is duly provided, I think February 2019. And then the appellant asks the respondent whether or not the respondent still has a copy of the Hildebrand bundle that I mentioned earlier, because that wasn't in the file either. And it doesn't appear to be in dispute that in July 2019, after some chasing in that month, the respondent confirmed that they did not have a copy of the Hildebrand bundle. Counsel, Miss Edmonds, who I mentioned earlier, was not then instructed until March 2020. And the actual explanation for that is that, which has been given in the witness statements and given at trial, is that Mr. Morgan was providing this assistance to the appellant pro bono because of their relationship, and she had always intended to instruct counsel if they got the papers together and at the point they managed to do that, and he had offered to pay for that advice at the point at which he thought it was appropriate to so instruct counsel. And the explanation, further explanation, is that in fact at the end of 2019, Mr. Morgan and the appellant had a falling out and short breakup, having had a somewhat volatile relationship, and then they reconciled, and then in early 2020 he instructed counsel, and counsel, as I say, advised in May 2020. So the appellant's case was that at no point until May 2020 did she have actual or constructive knowledge, such as to start the alternative limitation period of 3 years running under section 14A. And the respondent's case was that in fact she acquired either actual or constructive knowledge as early as late 2008, when she had started to discover his additional wealth and received that advice from Mary Kay, and if not then in around 2017, 2018, when she again began to learn of his increased wealth and could at that point potentially have instructed counsel or some other expert to advise her on the prospects of reopening a settlement, and that advice in itself would have led, as it did, to knowledge, because one thing I've neglected to mention is that Miss Edmonds telephoned Mr. Morgan in May 2020 and said to him, as an aside, not in her written advice, that in her view, the real culprit, to paraphrase here, was the respondent, and that the respondent may well have been negligent in the advice that the respondent gave to the appellant back in 2007-2008. Now, we accept that if it was incumbent upon my client to seek that advice earlier, that of course it is likely it would have led to the same result that Miss Edmonds or some other barrister would have said. You should be looking at your former solicitors rather than trying to reopen this settlement. The claim was then, this claim was then, after that May 2020 advice, intimated in 2021, following a dispute between the appellant and her legal expense insurers about the funding of the claim. There was then a pre-action process. In March 2023 it was issued. February 2024 there was a Cost of Case Management Conference at which the trial of a preliminary issue was ordered, and that preliminary issue was as to whether or not the claim was time barred. At that point, the appellant was relying on both Section 14A of the Limitation Act and Section 32 deliberate concealment. There is no appeal against the judge's finding in relation to deliberate concealment, only in relation to the Section 14A issue. And that trial took place in September, over 2 days. As I say, it was on Judge Russon 2 days in September 2024. The witnesses who gave evidence were the appellant, Mr. Morgan, and Mary Kay. And you have in supplemental bundle their witness statements of trial, which we may take you to. And you also have in the December application bundle transcripts of the evidence of both the appellant and Mr. Morgan, which again we may take you to.
Are you going to do that because you're saying that there are findings which the judge failed to make but ought to have made?
There is one finding the judge failed to make, which is the subject of Ground 8, Appeal Ground 8, which is as to the reasons for delay in 2019, between February 2019 and July 2019, regarding the query over whether or not the respondent had the Hildebrand bundle. And that was the subject of evidence, both in the witness statements, the documents, and in examination of the witnesses. That, if I could put it this way, that ground of appeal, Ground 8, is somewhat of an adjunct to Grounds 5, 6 and 7. And I was going to come back to summarise the grounds in a moment, but at a very, very high level, Grounds 1 to 4 relates to the period in 2008, 2009, and actual or constructive knowledge for the purpose of Section 14A at that point. Grounds 5 to 8 relate to the later period of time, circa 2017 to 2020, and the judge's alternative finding that if the appellant didn't have actual constructive knowledge in the earlier period, then she had constructive knowledge in the later period. And part of the judge's finding, which I will take the lordships back to when I get to that ground of appeal, was that there was a period of time when nothing happened at all in 2019, and I think it's paragraph 160 of the judgment, but I will take your lordships to it, that nothing happened at all, whereas in fact the evidence before the judge was that there had been a request for this Hildebrand bundle. Now, as I say, that's in a sense an adjunct to Grounds 5, 6 and 7, because the main thrust of the appeal in relation to the later period, Grounds 5, 6 and 7, is in relation to the appellant's impecuniosity, and whether or not that is a matter which the court can, and in this case should, have taken into account in looking at whether or not the appellant had taken reasonable steps to seek expert advice such that she could rely on the proviso that I've mentioned, Section 14A(10) of the Act.
In terms of the Hildebrand bundle, from February 2019 to about July 2019, when they didn't have it, even if you took that 6 months out of account and didn't hold it against your client, it wouldn't change anything, would it, on the date?
Well, in my submission it would, my lord, in the sense that there was a period of a few months in which they were still waiting for completion of the papers before they could then instruct counsel. Now, there's obviously a separate issue about whether or not my client, the appellant, can rely on the proviso, given the then further delay until March 2020 when counsel is instructed.
That's the point, yes.
So that's the point I need to address with your lordships in due course, of course. So, the judge's findings, as I say, were that the appellant had actual constructive knowledge by the end of 2009 for the purpose of Section 14A of the Limitation Act, meaning limitation expired by the end of 2012, or alternatively, that she had constructive knowledge by the end of 2018, meaning that limitation expired by the end of 2021. He also found...
Can we just identify actual or constructive knowledge of what? What precisely is the fact which you say is relevant for the purpose of subsection 8A, damage being attributable and so forth?
Yes, I'll obviously come on to address this in much more detail shortly, but the fact that she was unaware of, in terms of attributability, which is the subsection your lordships just highlighted, was that she was that there was some other option, effectively, in terms of the settlement of her ancillary relief application. There was something else that could have been done by way of further investigations and or, in particular, the nominal spousal maintenance order. So it's only as a result of knowing about that, the appellant says, about those things, but in particular the NSMO, that she is then in a position to attribute the damage that she has suffered by way of the under-settlement to the acts or omissions of the
So
respondent.
you say the fact is that there is some other option than a clean break. Is that
Indeed.
Is that it?
And
And not something, say, as general as the fact that she'd been badly advised.
no, my lord, no. And this is where the case of Whitcomb, that we'll both come back to, I'm sure, in some detail, comes in, because your lordships will have seen that grounds 2 and 3 relate to the Whitcomb case, in which we say the same and entirely analogous situation arose, whereby the claimant in that case had been had entered into a settlement of their personal injury claim, where there was a possibility that in due course their injuries could worsen, and they were advised that the settlement, and I'll take your lordships to the relevant passages in due course, but they were advised that the settlement would effect a clean break, that there would be no further recourse to the defendant in that case, but where the claimant in that case was not advised about the availability of a provisional damages order, which we say is analogous to the NSMO here, preserving the ability of the claimant in Whitcomb to return to court and seek increased damages if his condition should worsen, which indeed it duly did. And in that case, the judge at first instance, Justice Bourne, and then the Court of Appeal upheld the judge's decision in that case that that the claimant in that case did not have actual knowledge until much later, when he became aware of, as a result of consultations with further doctors, at a point at which he would then have gone to seek expert advice, was not then aware of the availability until a much later point of this alternative remedy. So we say the position is analogous here, and that until the appellant was advised in 2020, in fact what she was advised in 2020 was that the respondent may be negligent, and knowledge of negligence is not necessary for knowledge to accrue and for the limitation period of 3 years to begin running under section 14A. Section 14A, subsection 9, specifically excludes knowledge of negligence per se. But as we'll come back to, as Honourable Judge Russin in this case himself in his judgment noted, that in a case where, as was the case in Whitcomb, in a case where, because of a failure to advise, the professional negligence claimant does not know, that inherently does not know about something that they should have been advised about, will often be the case that it's only when they're later told about that alternative option, which may come very close, in fact, to revealing immediately that their original advisor has been negligent, that they then become they then have sufficient knowledge under the section for time to start running. So in this kind of case, I'm sorry about that.
I understood from what you said earlier that if we're looking at 10b, from facts ascertainable by him with the help of appropriate expert advice, the facts ascertainable were that there existed alternatives to a clean break. Those are the facts.
Yes.
Not the negligent advice, but the fact that alternatives existed. And that's what the expert would have told him. In a medical negligence, well, you could have surgery or you could have chemotherapy. Here, you could have a clean break or you could have a disposal thing.
Indeed, my lord.
Yeah.
Yes. Now, in fact, what actually happened in this case is that we went one stage further very quickly to your solicitors may have been negligent, according to counsel advised in May 2020. But
that's not the fact.
But that's not the fact.
That's the description.
Indeed.
The fact is, the factual reason why it is said that they might be negligent was that there are options available which weren't drawn to their attention.
My lord, yes. So, I've touched on this already, but just for completeness.
But it can't be simply that there is some other option, because your pleading is that Mrs. K, Mrs. Mary K, advised that there was more than one option. She said the advice was that the clean break was the best option, because the claimant couldn't trust Mr. Mahon to make future payments. So the advice given was that there is more than one option.
My lord, yes. So there was some advice shortly before the FDR, April 2008, and in fact, the appellant's offer, pre-FDR offer, was for, if I recall correctly, 5-year maintenance by Mr. Mahon. So there was a discussion prior to the FDR of potential ongoing maintenance. What there wasn't was any advice given, and this was in cross-examination. Mary Kay accepted that she may not have advised on the existence or merits of an NSMO at all, and the appellant's evidence was that she did not, and the judge in his findings appears to have accepted that that advice probably wasn't given. That was the advice that wasn't given, and that is advice of quite a different character to you could seek some short-term maintenance, which was then described as part of that offer by District Judge Ingram as pie in the sky, because at that point Mr. Mahon's assets or liabilities appear to outstrip his disclosed assets. So that's
I'm trying to identify the fact,
yes,
which is relevant for the purpose of the section, because until you've identified the fact, you can't begin to know whether somebody has actual or constructive knowledge of it. And when I asked you first time, you said that the fact was that there was some other option than a clean break, but it looks as though that was known to everybody. So are you now going to formulate something a bit more specific?
Well, my lord, perhaps I was a bit, and I apologise, too general in my description. We've made it very clear in the grounds of appeal and in the skeleton, and as I'll come on to in my submissions explain, that the specific fact, as it were, is that the availability of an NSMO was not advised upon. So when I said some other option, that was the other option I was talking about.
Yeah. Okay, thank you.
Sorry for the lack of clarity.
No, that's fine. It's just that it's helpful to have that foundation laid so we know where we are going forward in the argument.
So, so the grounds of appeal, which are in tab 1 of the core bundle, but I'll summarise now briefly if I may. As I said, there are two broad categories, grounds 1 to 4, and in terms of the time period, that's 2008 to 2009, and grounds 5 to 8 is the later period. But within grounds 1 to 4, and if your lordships want to look at them as I describe them there, it's page 15 in the core bundle, where they begin. Right, I'm going to paraphrase them if I may, for the current purposes. Grounds 1 to 3 relate to the judge's finding of actual knowledge by the end of 2009, whereas ground 4 relates to the judge's alternative finding in relation to the earlier time period of constructive knowledge. So that is the subdivision of grounds 1 to 3 on the one hand and 4 on the other. And in fact, there is a further subdivision within grounds 1 to 3. So ground 1 was wrong to find the appellant had actual knowledge by no later than the end of 2009 on the basis that said finding was not supported by the evidence, and was a finding on which on the evidence no reasonable judge could make.
I mean, sorry to keep interrupting, but this illustrates, I think, the importance of identifying the fact, because if the relevant fact is the availability of an NSMO, then your client never knew about that until advised by counsel in 2020. So any finding of actual knowledge would have to be wrong. On the other hand, if the relevant fact is something broader, such as that she's been badly advised, then the possibility of actual knowledge at an earlier stage does arise, I suppose.
What, my lord, one has to bear in mind, your lordship obviously asked me to narrow down what my client was not aware of, but the test under Haven Fawcett for actual knowledge is knowledge of such facts about both damage on the one hand and attributability of damage to actual emissions on the other, as would cause a reasonable person to begin to investigate the matter. So the judge's finding was, well, by late 2008, 2009, the appellant could see that Mr. Mahan's wealth was increasing, and that was of itself enough to, as it were, set alarm bells ringing, give her the level of knowledge described in Haven Fawcett's. But the appeal is premised on that being wrong, because for the very reason that is such a generalised and, as it were, abstract or very, very simplistic high-level view of the matter, because what she didn't know at the end of 2008, beginning of 2009, was the existence of an SMO. It's also right to note, my lords, that the claim against the respondent was not premised solely on the NSMO. It was also that the breach of duty pleaded, which are in the pleadings in the bundle, were also that, that the respondent had failed to give adequate advice on other investigations into Mr. Mahan's assets. So, for example, my lord.
If we look at the other side of the coin, because we've all been trying to identify the facts that she didn't know, that meant the 14A test is passed. But what did she know? She did know that she had settled on the basis of a clean break. She did certainly suspect, if she didn't know, that the agreement didn't reflect the whole of her ex-husband's assets, either because he'd hidden them or because he's acquiring them pretty quickly afterwards. So she knew that the settlement didn't cover the existing situation, and she was told by the solicitors that there was nothing she could do about it effectively because she couldn't reopen.
Yes.
So against that background, you say the fact that she needed to know and didn't know was what?
So, well, I was just about to address that, because the NSMO is the, as it were, the central point.
I think so.
But as I was just saying, the respondent had given certain advice about whether or not to pursue investigation.
Mm-hmm.
And the appellant's case was that advice was also negligent, in that the advice, summarised very briefly, was there's no point, it's too expensive, it's not proportionate, who knows whether we'll find anything, you should just move on with your life, you can support yourself, which is all part and parcel of the idea of the clean break as well. Even though a non-clean break was, as I've already said, at one point mooted, in general, the consistent theme of the advice was you just need a clean break, you need to start again, away from your ex-husband, apart from the children. So that advice was given, and that advice, the appellant says, was negligent. But what she also didn't know was that there were other options like a pension sharing report, forensic accountancy, evidence, tracing his assets. The counter to which, at a full trial of this matter, might well be you couldn't afford to do that. You couldn't. This was not likely to be practical. But that's not the issue, respectfully, that we're dealing with today, because that's a matter of causation, which will be dealt with as a full trial of this matter. In terms of this issue, what matters is, in my respectful submission, what she was advised, what that led her to believe up to and shortly after the settlement, and then what the effects of the advice in late 2008 and early 2009 would have been, and whether or not, this is for the purpose of grounds 1 to 4, whether or not, as against the background of the advice she was in fact given, that later advice would have given her the Haven Fawcett's actual knowledge or constructive knowledge.
If you go back to fact, because it's not actual knowledge, if you're talking about the non-MSO things, the forensic accountancy, the tracing and the pension sharing,
yes,
she didn't know the details, but she knew there were other things that could be done, and she'd been told that they were too expensive or too difficult.
yes.
So she knew the fact that those existed. She knew she'd been told not to go down that route.
she was told there was effectively no point. And that, and the advice that she was then given in 2008, 2009, late 2008, 2009, wasn't, this is going to be one of my central submissions, wasn't to the effect of, oh, perhaps we actually should have got the forensic accounts report, or we should have got the pension sharing report, or we should have pursued disclosure against Mr. Mahar more vigorously. The advice that she was actually given was, well, you've only found out about some after the event wealth by way of the Porsche, the new company which had been incorporated on the 29th of April, so 4 days after the FDR, and an insurance policy which appears to be for her benefit anyway, as it turned out. So that's all after the event. That's all new stuff that we couldn't have known about then because it's new stuff. New matters. We couldn't have known about because it's new, and so that later advice in 2008, 2009 didn't, as it were, give the lie to the earlier advice. It didn't reveal in any way, shape, or form either that there was an SMO available, or that the earlier advice might be the reason why. It's not about whether or not it was negligent, as we've discussed, but might be the reason why she had suffered some damage by way of an undersettlement. Because if these matters, the Porsche company, etc., only materialised later, they were necessarily, according to Miss Mary Kay's advice, which, as your Lordship asked about earlier, we accept was correct on that point, necessarily were after the event and not matters the court could have taken into account at the FDR or at some other contested hearing if it had not been settled. I hope that deals with your Lordship's question. So ground one is, regardless of the Whitcomb case, the advice, the judge's finding was that October 2008 to May 2009, the appellant was told enough by Mary Kay that she should have realised that there was an undersettlement and that it was attributable to the act submissions of the respondent. We say no such thing for the reasons I've just explained. Grounds 2 and 3 relate to the Whitcomb case that I've mentioned, and I've already effectively outlined what those are, which is that for all intents and purposes, this appellant was in the same position as the claimant in Whitcomb. She'd been advised that there would be a clean break. She hadn't been advised about the NSMO, just as Whitcomb hadn't been advised about the provisional damages. And as I've already explained, I think, therefore she didn't have the actual knowledge until told much later. And in particular, in relation to ground 3, the attack there is on the judge's rationale that this was the NSMO was merely a point of detail. Now, it is right, as I've just explained to your Lordships, that there were other things advised about and that there are allegations of negligence in relation to those other things, but the NSMO is the, as I've already said, the central facet and the critical failure by the respondent. And then ground 4 is constructive knowledge. I think I've already mentioned that the appellant's case on that is that she's entitled to rely to the proviso, on the proviso to section 14A10, which, as I say, or I perhaps just say more clearly now, provides that whilst a person's knowledge includes knowledge they might reasonably be expected to acquire by facts, from facts observable or ascertainable by them, or so ascertainable with the help of appropriate expert advice which it's reasonable to seek, a person shall not be taken to have knowledge of a fact ascertainable only with the help of expert advice, so long as they have taken all reasonable steps to obtain, where appropriate, to act on that advice. And so there is case law which we'll return to, shows that in particular the Halliwell-Landau case, Gosden Halliwell-Landau, that it's a matter of fact and degree, but it can be appropriate for a party to return to their original professional advisor when concerned about their situation and rely on advice from that advisor and therefore avail themselves of the proviso that I've just read out, section 14A10. And we say that going and speaking to Mary Kay in that period was reasonable.
Ground 4 is your only challenge to constructive knowledge in the 2008-9 period,
My Lord, yes.
and I think you're making clear that your only case is the proviso.
My Lord, yes.
So the subsection takes matters in two stages. The first is knowledge which he might reasonably have been expected to acquire, etc. And then, but the proviso. So you're not challenging the first part of that. So she might reasonably have been expected to acquire it, but you say because she went to her former solicitors, the proviso kicks in.
Precisely so, my Lord, yes. So I'll come back to some submissions on the case law on that in due course, if I may. We also have the Morris and Knight's case in the Vulnerable Authorities, which itself sets out various recent cases and a helpful summary of the law on that. Grounds 5, 6 and 7, as I've already said, relate to impecuniosity. And this is a matter of statutory interpretation, but and as to which there appears to be no reported case directly on point. And I think my learned friend and I agree on that, and did at the trial. That's going back to the proviso that we were just examining. The question is whether or not the claimant has taken all reasonable steps to obtain and, where appropriate, act on that advice. And the sub-questions, as it were, are, is that a purely objective test, or does it take into account characteristics of the claimant themselves? And if so, which characteristics? And the appellant's case, based on the Gravguard case, which we'll come back to, is that the test is not wholly objective, and Gravguard talks about this, about the claimant or the party for the purpose of that proviso not being some wholly hypothetical claimant, and alludes to characteristics of the claimant being potentially relevant, but it's also right to note that in both that case and Gosden and Halliwell-Landau, the court made clear that not all characteristics of any claimant can be taken into account, and those which are peculiar to the given claimant, which have nothing to do with a claimant in that position, whatever that means, and we'll come back to examine that, could not be taken into account. So the death of a loved one, something of that nature. And the appellant's case is that impecuniosity is not in that category. Ground 5 is impecuniosity should in fact be taken into account, and in support of that we say in Gravguard obus dicta that the court did allude to that. But ground 6 builds on.
Before we leave that, and following on from my Lord's question in relation to the earlier period, you are accepting then that at some dates you've not yet identified, it might reasonably been expected that the appellant could have acquired facts ascertainable, i.e. the existence of other options, from an appropriate expert advisor. So at some stage it was reasonable to do that, and the only reason why you'll identify the date that didn't happen was because of lack of resources.
Oh yes. So to deal with your lordship's question, the period at which the appellant accepts that you should start investigating, as it were, is the very late 2017, early 2018 period, and that's the way her case was put below. She relies on the proviso to section 14.8.10 to say that once she began to learn of Mr. Mahan's significantly increased wealth at that point, she did then take reasonable steps to obtain expert advice, but that what was reasonable for her was affected by her impecuniosity. And there is a question as to whether the judge made a finding that she was impecunious, or simply, for the purpose of his analysis, assumed that, we'll come back to the wording of judgment in due course, but he at the very least assumed that she was throughout the relevant period from, in fact, from the divorce settlement all the way through until she received counsel's advice in 2020, but certainly during this later period in question. And so there, for the purpose of this analysis, there is, as it were, no issue about her impecuniosity. Now, what there might be, if this court considers that the judge hasn't made a finding on that issue, of whether or not she was in fact impecunious in that period, what there might be is a need, if this court was otherwise with the appellant, for further findings to be made on that issue in due course before the preliminary issue can in fact be fully disposed of. But your lordships now have the benefit of the evidence from the June and December applications, which go into greater detail about the appellant's means. And so if your lordships are minded to admit that evidence, then the appellant says, on the basis of her original evidence at trial and that further evidence, that fresh evidence, if your lordships are not satisfied the judge made a finding of impecuniosity, your lordships can yourselves make that finding in dealing with this appeal.
It seems a very nebulous thing, impecuniosity, and I'm not sure we've got any findings in the judgment as to exactly what her financial position was, or indeed the reason why it was whatever it was. I mean, I think I read somewhere, I can't find it in the judgment at the moment, the judge said, well, she had previously had a good job, a well-paid job, and
yes,
she could have gone back to something which was similarly paid, but she didn't.
Yes.
So why does that then
So she
not
was
become a factor relevant to take into account if one has to look at someone in the position of this claimant?
my lord, to
And
your lordship is,
and the inquiry then sort of goes on forever.
well, and that is the fundament of the judge's rationale, in fact, was that impecuniosity, in his view, under the authorities such as they were, was not relevant, but that he also considered, the judge considered, that it could not be for the purpose of section 14A, 10, the proviso, because of the inquiry that would be necessary in order to establish that impecuniosity or not. My submission will be that that is an exaggerated fear, and that that inquiry is something that is capable of being dealt with by evidence, and no doubt any given claimant will have a challenge in proving, as it were, their impecuniosity, but it can be done. And indeed, your lordship is of course right that there is reference in the judgment to the appellant having been an environmental consultant earlier in her life and having earned, I think, £70,000 a year. But then she went to look after the children, and then there were various things that happened. And ground 6, of course, builds on ground 5 and says, even if general impecuniosity is not relevant, impecuniosity that is prima facie caused by the negligence of the defendant, respondent here, is relevant. And the reason we say that is because that is, to use the Gravguard formulation, about the position of a claimant in the position of this claimant as a result of where they found themselves. And further, I will submit, this is not in my skeleton, I'm afraid it's a point that came to me later, but it is in the authorities. My little friend cites an authority called Adams and Bratton Forest Council, which is a personal injury case, which he cites for another reason. But that case, for the House of Lords, I will take your lordships to the speech of Lord Hoffman, Baroness Hale and others, in which they say that whether or not an injury inhibits a claimant from seeking expert advice is relevant to the identically worded or materially identically worded provision under section 14 of the Act, which is set out in the judgment which we'll come to, is relevant to the question of what reasonable steps are to go and seek expert advice. And the analogy that I will seek to draw is that where the injury, as it were, is economic loss, as here, caused by the negligence of the defendant, and that itself inhibits one's ability to go and seek expert advice, that can therefore be taken into account. So I seek to draw an analogy from the Adams case.
But what does the person in the position of the claimant mean? Again, it depends on the level of specificity, doesn't it? It could be that one would think of a divorced single mother of teenage children. Well, many women in that situation would go out to work and maximise their earning power. I'm not in any way criticising whatever choices your client made. No doubt she did what she thought was best for her and her family. But many women in that position do earn and would not be in a position to plead impecuniosity, which after all is not talking about grinding poverty. It's the lack of a few £1,000s to instruct counsel is what we're talking about.
Yes, my lord, that is the issue with which, respectfully, this court needs to grapple, because there is no authority on this point. But if I could just take your lordships briefly to the judgment, please. This is in core bundle at tab 5, page 85. At paragraph 162 in the judgment. At the bottom, in that paragraph, the judge talks about payments that have been made by Mr. Morgan for the appellant's 50th birthday and so on, but the crucial passage is the last 3 lines. And this is the quasi-finding or assumption that I referred to earlier. I'm prepared to assume that Miss Kay had no claim or even expectation that Mr. Morgan would pay for either the party or the advice. And then this is the critical part, my lords. And also that her own financial resources were throughout the 15 years from April 2008, the long stop period, as stretched as she says they were in 2018 and 2009. So that's the at least assumption that the judge makes. He also records something else which is of relevance to this, and to my lord's last question, which is at paragraph 107 on page 75, core bundle. So there, the judge is talking about Miss Kay's, the appellant's evidence, and he says, she also explained at length in her witness statement how her own impecuniosity meant that she was not able to instruct HCR is Harrison Clark Ripley's, the firm at which Mr. Morgan was then a partner, formally, dependent upon Mr. Morgan for his pro bono assistance and his agreement to pay for Miss Edmonds' advice. And this is the critical passage, my lords. Her straitened circumstances were, she says, essentially attributable to the inadequacy of the settlement, including what proved to be the relatively low sum from the sale of Manor Cottage and the cessation of Mr. Mahan's child maintenance payments after 2011. In the note page, he said, the judge said, I'm sorry, the periods of separation from Mr. Morgan also contributed to the delay in instructing.
The judge didn't say that. That's the judge's recitation of her witness evidence.
Yes.
It's not a finding.
I understand that.
In that paragraph.
Yes. So the judge doesn't then make any finding about any causal link between her, as he puts it, straitened circumstances, straitened financial situation, I think, straitened circumstances, and the potentially negligent advised settlement. He simply doesn't make a finding, but he also doesn't demur from what she says, and in his later assumption says, or finding slash assumption, if I can put it that way, says prepared to assume that she had no claim, etc., and that her resources were as stretched as she says they were. Now that's not quite saying as a result of the settlement, but the judge simply doesn't deal with it. So again,
he does at the end of 161. He does record your submission, doesn't he? The last sentence.
Yes, my lord, that's absolutely right. He does say that I had submitted that it was said to be caused by defence alleged negligence, but he doesn't then go on to find that whether or not that causal factor was there. And the critical part of his decision on this point is at 163 over the page, on page 86. In the last 3 lines of paragraph 163, he says, such conjecture about the vicissitudes in a claimant's financial position over a potential period of 15 years provides a clear indication that her wherewithal or lack of it is irrelevant to the inquiry under section 14A. So, in answer to my lord's question a moment ago, I said that the judge's rationale on this point was it's just too difficult because it's so, as the judge saw it, inherently difficult to establish whether or not someone has been impecunious. And although he doesn't say this, perhaps by extension, what the cause of that is over such a long period, it cannot have been intended to be taken into account when Parliament enacted section 14A10. That's his rationale. That's then the judge's rationale. My submission is that is not based on any sound, cogent logic, and is bearing in mind what's also said, as I've said, about section 14 in the Act by the House of Lords, and what's said in Gravguard, incorrect. So ground 6 was to build on ground 5 and say, even if impecuniosity generally isn't relevant, it's on the face of it caused by negligence is his. And it, again, we come back to the point that if there is no finding on this, then it might be necessary for the courts to make a finding, not just about the impecuniosity, which I say is established both originally but also by the further evidence in the application bundles, which say in terms as well that the appellant, says in terms that impecuniosity was caused by the position she found herself in. Now, she wasn't, my learned friend did, of course, cross-examine her on these issues to an extent at the preliminary issue trial, but, as I mentioned in my supplemental skeleton, that there was no disclosure at any great length. There was no interrogation of disclosure by the respondent, no interrogation of the appellant's disclosure, by the respondent. There was no request for further information. It was dealt with in the witness statements, but not at great length. It's now dealt with a bit further in the new witness statements. But in my submission, it appears that because of the format of this preliminary issue trial, it was a 2-day trial, and the way that had been set up, there wasn't, in fact, it seems, sufficient time to explore that absolutely fully.
Does it matter? I mean, if you're saying you've got to look at to see whether there's a link between the impecuniosity and the negligence. I mean, part of the problem I thought was that the matrimonial home had fallen in value because of financial events, and the claim against the builder was successful, but they declared themselves bankrupt, so there would have been more money even under the settlement, but life intervened.
But that, my lord, is where the NSMO comes in, because it's that mechanism that would have enabled the appellant
to have gone back and said the things we thought that were going to take care of me have fallen away, and therefore that's why I now need to come back.
And she was, and it is, of course, as your lordship says, partly because of those that have fallen in the property market, the builder making themselves insolvent, that she ended up in the position she was in. But had she had the NSMO as well,
she could have gone back and said, look, this was intended to protect me, and for whatever reason, it's not protecting me anymore.
My lord, yes.
But presumably the settlement was not intended to set the claimant up for life, but simply to make a fair division of the matrimonial assets. What was the evidence about what the claimant was actually doing between 2008 and 2020? Was there evidence about whether she was working, and if so, what job she had or what it paid?
My Lord, I'd need to go back to the trial witness statements. I confess I haven't refreshed my memory on that recently. My recollection is that she did describe, in broad terms, the course of her life over that period, but not in fine forensic detail.
Well, I mean, for a case of impecuniosity to be run, that sounds pretty basic to me.
Well, she said, in terms, I'm in this position because I have no money, and I've had no money throughout because of the negligent advice of the respondent, and set out some details of her life in the intervening period. And I, if I may, could return to that later, having consulted the statements again. But
All right.
I'm sorry, I can't give you
Okay,
an
fair enough.
answer at this moment. So ground, just returning to the very high-level introduction, I'm sorry it's taken so long of the grounds. Ground 7 was that that the judge had erred in finding that she was not entitled to rely on pro bono assistance from Mr. Morgan as constituting reasonable steps. So Mr. Morgan, as I've said, was not a family law specialist. Obviously, commercial litigator, someone with legal skills and the ability to marshal her papers and then instruct counsel, but doing it pro bono, and that really comes back to the impecuniosity point, because she had no other option. Her case was, he is the only person who can help me get advice from a true expert, namely counsel, and I took reasonable steps to obtain that expert advice from counsel by relying on his pro bono assistance. The judge decided that she was not entitled to rely on that. We'll come back to precisely why. And then, as I say, the final ground is to do with the lack of taking into account of the delay between early 2019 and July 2019 in relation to confirmation that the respondent no longer had the Hildebrand bundle. So, after that rather lengthy introduction, may I turn to ground 1, please? So can I say, my learned friend set out in his skeleton at paragraph 41, quite correctly, I would respectfully say, what the test is. So this is at tab 12 of the core bundle, page 192. And I may as well, I think, address this now. These authorities not in the bundle, because hopefully this is not, your lordships, I'm sure, would accept these propositions. In relation to findings of fact and challenging a judge's decision, I have to show that it wasn't supported by the evidence, or was a decision that no reasonable judge could have reached on the evidence. And then the learned friend helpfully cites the Haringey and Ahmed case, and quotes from that, saying that when an issue is taken in the various of assessment of facts, then the appeal court does not carry out a balancing task afresh, but asks whether the decision of the judge was wrong by reason of some identifiable flaw in the judge's treatment of the question, such as a gap in logic, lack of consistency, and so on. So, contrary to what my learned friend goes on to say in his skeleton, then, I would say that we have in fact established the lack of support in the evidence. But unfortunately, and insofar as this was about the learned judge applying section 14A to the facts, he was carrying out an evaluative assessment, which we say he did illogically. But that unfortunately does mean that I probably need to take your lordships to quite a bit of the evidence. My lords, I don't think there's anything between us on the test for, we're dealing with actual knowledge in these first few grounds, and what the test is under Haven and Fawcett. That test is also helpfully set out in the judgment of the Court of Appeal in Whitcomb. But I don't know if the lordships need to take to that now.
I think it would be helpful just to see what the test is said to be?
My lord, yes. So this is Whitcomb in the Court of Appeal in General Authorities at tab 13. There's quite a lot in here, but I'd like to take your lordships to what I think is the nub of it, which is at page 260 in the Bundle of Authorities, paragraph 49 in the judgment. Which in fact is mostly Court of Appeal quoted from first instance judge's decision, but there is a little gloss on it at the end. So this hopefully encapsulates the test. So paragraph 49, as Justice Bourne pointed to Lord Nichols' observations at paragraph 21 of Hayward that, and over the page, there may be cases where the defective nature of the advice is transparent on its face. It's not suggested that was so here. Time to run. Something more was needed to put Mr. Hayward on inquiry. The time to start running, there needs to have been something which would reasonably cause Mr. Hayward to start asking questions about the advice he was given. And then paragraph 23 in Hayward, Lord Nichols identified the relevant date as not when Mr. Hayward first knew he might have a claim for damages. And there are several formulations in Hayward, just pausing there, but this is the one that's perhaps most famous. But when Mr. Hayward first knew enough to justify setting about investigating the possibility that Mr. Ostranger's advice was defective. So, I think I alluded to that test earlier, but it's the first knew enough to justify setting about investigating the possibility. So,
but we really need to see Hayward, not somebody else's description of one sentence of Hayward, because in order to know whether those words have any meaning, we need to know what the claim is all about and what the evidence is all about, because it's not the evidence, it's the facts. And the facts here are, you say, the non-availability of a particular one other alternative. And I'm always worried about taking sentences out of context. I'm even more worried about taking somebody else's description in a later case of a sentence out of context. But it's a matter for you.
my lord, I was simply trying to keep submissions short, and on the basis there's nothing between us, and in my submission, the facts of Hayward don't particularly help us in looking at this case, and really all that we need is the test. But I'm obviously happy to take your lordship to the facts of Hayward in a moment if required. May I just finish looking at this for a moment, please? So it goes on to say, claims in Hayward ultimately failed, having not attempted to discharge the burden of proof in respect to the relevant date, instead focusing on the date when he knew he might have a claim for damages. And then, first instance judge in Whitcomb quoted Lord Mance in Hayward, who gives this slightly different formulation, but which is particularly relevant in a Whitcomb type case, and which is what we say this case is. This case is a Whitcomb type case. It is, in my opinion, wrong to suggest that all the claimant needs to know is that he's received professional advice, but for which he would not have acted in a particular way which has given rise to loss. A claimant who has received apparently sound and reliable advice may see no reason to challenge it, unless and until he discovers that it has not been proceeded by or based on the investigation which he instructed or expected. And then finally, the gloss I mentioned is that the Court of Appeal in Whitcomb says paragraph 52, I forget which judge, I'm sorry, I would add this is particularly the case whereas here the claimant is unaware that he has lost anything by following apparently sound and reliable advice. So that was the point I sought to draw out earlier, which is that the position is different if you don't know, as it were, that you've not received certain types of advice, but you've apparently had a set of advice that's cogent on its face and appears to be reliable.
I mean, the territory we're in, which is difficult, I think, is that of identifying the fact, as my lord was saying. So we see from here Lord Nichols saying there has to be something more, but what it is would be useful to identify.
The problem is looking very quickly at Hayward, not having read it in detail before. He's talking, Lord Nichols, about the degree of knowledge required at paragraphs 8 to 9 and following. Not, that's at page 99, not what facts needed to exist. So I think it's very dangerous just to look at things out of context.
I mean, he does sort of do both, doesn't he? But I don't think it's entirely easy.
No. And as that passage just identified, Mr. Hayward did not, in fact, try and prove the right thing in Hayward, which probably doesn't help us either. And it is an inherently, my submission, an inherently fact-sensitive exercise. So the test is formulated in Hayward as then quoted in Whitcomb. But knowing what is enough in terms of facts to justify setting about investigating a claim.
The two separate things, what facts
Yes.
and what degree of certainty about the facts. And it looks as if Lord Nicholas was more concerned at the beginning with what degree of certainty.
Yes.
We're still at first base, what facts.
Yes.
And that's why the words of the Act are actually quite helpful, old-fashioned, but
Yes.
if you actually apply the words of the Act, it's often easier to answer questions. Anyway.
Yes. Well, we've talked about the facts, and the facts are that this NSMO was available, never advised on, and that it was, as it were, inadvisable to bother pursuing any other lines of investigation, some of which were not even discussed, but to the extent they were discussed, very cursory advice was given. So, and I then went on to make submissions about how the advice that was then actually given in 2008-2009 was on a different point. It was about whether or not the new matters, the Porsche, etc., gave a chance to reopen it. It wasn't about anything that would give the lie to the earlier advice. So, my Lord, of course, yes, the parts quoted in Whitcomb from Hayward are about the degree of knowledge in particular, and one has to accept that the threshold is not very high, as it were, as a result. Hayward says you have to know enough to start investigating it. Now, what enough is in a given case depends on the facts of that case.
And it's easier if you look at paragraph 17 of Howard at 101. There, he gave the man money and told him to invest it, and it was worth less afterwards than it was before. So it's much easier because you're not talking about knowing about the existence of alternatives that you could have done for a settlement. It's just, please look after your money, and you expect it at least to come back, preferably with interest. It's a lot easier in this case, isn't it?
So just breaking it down for a moment, we're in Whitcomb. Do you need more of Whitcomb at this stage?
I don't think I do.
At some stage, I think it would be helpful to go through Hayward's in a bit more detail.
My Lord, yes.
I don't know whether that's now or at some other point.
Well, I'm grateful to my Lord for highlighting paragraph 17 in Hayward. It's at page 101 in the Bundle of Authorities. Because that shows that, as my Lord said, it's a very different factual circumstance to our factual circumstances. Paragraph 17. The judge's approach was that Mr. Hayward knew all the material facts as they occurred. He knew the terms of Mr. Orstring's retainer. He knew the advice Mr. Orstring gave him. He relied on that advice for the consequence of the money. And this is the critical passage. The causal connection between the advice and the damage was patent and obvious. The only thing Mr. Hayward did not know was that it was negligent. But those matters are irrelevant. He said section 14a, subsection 9.
But then, this is where I get a bit confused. If you go on, in paragraph 19, latter part, the conduct alleged to constitute negligence was not the mere giving of advice. The conduct alleged to constitute negligence was the giving of flawed advice. That feature of the advice cannot be brushed aside as a matter of detail, nor could it be treated as a matter going into particulars. And then you get on to this business of there may be cases where the defective nature of the advice is obvious, but
yes,
you need something more.
Yes, which is the part that's then quoted in Whitcomb, which
Yes.
I rather short-circuited. And as you can see, my Lord, from the highlighting in the bundle, I think it's my own friend who particularly relies on these passages, 21 and 23. But as I say, in my submission, Hayward is a fairly stark example where where the House of Lords then were able to talk about also about the degree of knowledge required, and this is the leading and only authority at that level on this section.
Well, if the question in Hayward was, is there something which would reasonably cause Mr. Hayward to start asking questions about the advice he was given, might not the equivalent in this case be whether the claimant should have asked, how come I have ended up with such a terrible deal, which I now find I can't do anything about?
That is the way, effectively, the judge in this case approached it, my lord. And in my submission, that is, with the greatest respect, too simplistic a way of looking at it. And I come back to the point that it is about the mismatch between the nature of the advice given pre-settlement, which is about whether or what remedies are open to you and whether or not you should bother pursuing them based on his assets at that point, and then the advice given by Mary Kay late 2008, early 2009, which is about apparently after acquired assets of Mr. Mahan, and whether or not that gives a discrete basis upon which to reopen the settlement. There's no equivalence between those two things, and the one does not give reason to question. The later advice does not, in my submission, give sufficient reason to question the earlier advice, even if not going so far as thinking about whether it's negligence or not, about whether there is in fact any causal link. And the judge, in his judgment, dealt with this in a very broad brush. You must have known something was up kind of way.
But you've got to break down two things there. It would have been reasonable for her to go and seek advice. Look at this. This was supposed to take care of me, and it's not. This was to make sure that his assets were taken into account, and they haven't been. Look at the port. And therefore, it was reasonable on this analysis to make inquiries. And the reason why I think you're saying the time didn't run is because the inquiries that she made were reasonable. She went back to the firm and said, look what's happened, and they told her. They put her off the scent, however you want to put it. But that's the flaw in the judge's analysis, you're saying. Not the fact at the moment that nothing had made her, nothing had sort of, if you like, put her on notice that inquiries ought to be made as to the mismatch between what was sought and the outcome. I haven't put that well, but you can see what I'm saying.
Well, of course, yes. So the mismatch that I was just describing relates to actual knowledge. So she, in my submission, she's not given any, she's not, does not become aware of any facts which give rise to actual knowledge under the terms of section 14. What my lord has just been describing about going and seeking advice on the reasonableness is precisely the appellant's case, but that relates to constructive knowledge.
I agree with that, yes.
Yes. So the mismatch is about did she have actual knowledge, and Haven Fawcett's and Whitcomb are all about actual knowledge. And then we also have to ask the question, and this is where ground 4 comes in, even though she didn't have actual knowledge, we say at that point, should she have gone and sought advice, given that she found herself in a worse, in an apparent, well, she was in the same situation, but she starts to learn about her husband's increased wealth.
Yeah.
And we accept that at that point, it is reasonable to go and seek further advice. Is there anything I can do about this? But she does that. She's entitled to go to Mary Kay. And Mary Kay says, no, there's nothing you can do about it. And when she says there's nothing you can do about it, that both entitles my client to rely on the proviso, and also, because of what she says about what can or can't be done about it, it doesn't give rise to actual knowledge. So may we now please turn to the judgment at tab 5 in the core bundle, because there are a couple of passages before we get to the judge's reasons that are, in my submission, illuminated. So at page 74 in the bundle, tab 5, paragraph 102. Now, again, this is as my lord noted earlier, this is the recital of the appellant's evidence by the judge in his judgment. But it is where this theme starts in my submission in the judgment, and the judge's treatment of the evidence is clear from this point on. So the judge at paragraph 102 said Mr. Kay's suspicion from the outset that Mr. Mahan had not given full disclosure of his assets or income is consistent with her approaching the firm in October 2008 and March 2009 to discuss the possibility of reopening the settlement. But this is the critical passage. Though it is important to note that at that early stage, the idea was driven by a change in her own financial circumstances rather than her having very much greater suspicions about Mr. Mahan's wealth than those she held before the settlement. And he goes on to describe her evidence that she's seen him driving around the Porsche, the existence of the life insurance policy and the new company. So the judge notes there that her case was not that she had any greater knowledge of what he might have had before, but simply that he seems to have acquired some new wealth. The next passage in the judgment, which I'd like to draw your lordship's attention to, is on page 80, paragraph 130. And I'm just working through the judgment in order, highlighting the relevant passages that lead to the points I'm about to make. But it goes back to one of my lord's questions earlier, which is about whether the NSMO would have been made. Mr. Hall also noted that Mrs. Kay accepted in evidence she may not have given specific advice about the availability of an NSMO as opposed to a clean break, which is at odds with one. In her testimony, so the judge records here Mrs. Kay's testimony, Mrs. Kay said that if the ancillary relief claim had gone to a final hearing, it was likely that an NSMO would have been made. So that's going back to my lord's point earlier about was this a matter of course? Not necessarily, but the respondent's own evidence was it was likely that it would have been made.
I see it, just before we get there, 101, which where you took us to, it was near where you took us to. Her evidence was she'd always believed that Mr. Mahan hadn't provided full disclosure.
Yes.
She felt she didn't get a fair deal, but she'd been advised it would have involved a lot of costs to investigate this further.
Yes.
Well, that's not the solicitor saying, we're telling you not to do it. It's them saying, if you want to investigate this, we can, but it's going to cost you a lot of money, which no doubt was true, because it would cost a lot to investigate. So you say that one of the heads of negligence is that they didn't advise her properly about that, but her own evidence seems to be that they did, but she decided it was too expensive to ask them to do that.
Well, that recitation of her evidence does not, in fact, encapsulate in my submission that the full gamut of what was alleged and of what the appellant's case was, which is captured in the pleadings and admitted in the defence, in fact, in large part.
But isn't there two things? Even at the time of the settlement or shortly thereafterwards, she thought he has kept information back from me. He has things that I don't know about. That's one thing, and that isn't to do really or principally with the NMSO. That's to do with the fact that he hidden something. Later, he becomes, it is said, very successful and has 22 companies and everything else. And he's got new wealth acquired after the divorce.
Yes.
And then if you're going to acquire something after the divorce, you needed the NMSO to reopen it. But there are two separate things. The NMSO wasn't the principal thing that was at issue, it seems, in 2008. What was at issue in 2008, the material facts, was that the settlement did not reflect the respective financial positions of the parties.
Respectfully, I would submit that it was both of those things, as I think I've already submitted today. And although, so the later wealth, the 22 companies that come into being,
Yeah.
is relevant in the sense that it would have both provided an opportunity under an SMO of sufficient length, because they can be made indefinite or they can be made for a period of time, to return to court and ask for greater provision from her ex-husband. But it also may represent the fruition of his hidden assets. So he may have had capital hidden away in various places that he was then able to use to establish companies and so on. And that's the appellant's case, a case that I accept is not an easy one to make out in terms of causation. But again, that's not the point that we are respectfully dealing with today.
So it's existing concealed wealth in about 2008, and in 2017 onwards, it's a possibility both of the benefits of concealed wealth plus any new wealth acquired.
Yes.
It's
So, and the way in which it was put in the pleadings was that at the very first meeting in December 2007, these matters were said, and these are all admitted in the defence at tab 8 in the core bundle. But I hope I can just canter through them quickly, and my learned friend will say if I've got anything wrong. That Mrs. K had advised in that first meeting that costs should be avoided, but she had not yet read the papers, including the Hildebrand bundle in depth. Now, she says in her defence that she said she was going to go on to do that. That the appellant had told Mrs. K that Mr. Mahan, his brother and sister-in-law, were tight-knit professionals and would be difficult to deal with. Mrs. K said that fancy lawyers weren't needed to fix the problem. That Mrs. K said something about it not being unusual for an Asian family to help secure assets to prevent them being accessed by an ex-spouse. That Mrs. K said the court would be unhappy with the level of costs. That it was not worth further considering the Hildebrand bundle on proportionality grounds. That the appellant told Mrs. K to an extent about what she believed about the hidden assets. Mrs. K said there should be a clean break, although it was pausing there as disputed as to why she had said that, but there was no dispute on the defence that she had said that, and the dispute had gotten way out of hand. So a variety of bits of advice were given even at that stage, not just going to cost, going beyond the passage that we've just looked at paragraph 101, I think your Lord alighted on. And
well, that's the pleading, those are the allegations, but
yes, well, and
the evidence is what the judge records.
Well, they're admitted, my lord. So, as it were, the judge had to take those into account, and he is describing the thrust of her evidence, but the case was wider than that. So, I was going to take your lordship to the other parts of the judgment which are relevant to ground 1, and I should say these are in fact relevant to all of grounds 1 to 4. In ground 1 at the moment. So, at paragraph 130, we've seen that there was an acceptance that Germaine was given specific advice on the NSMO, and that it was likely one would have been made as a final contested hearing. I think I should probably go on and refer to the rest of that paragraph briefly. She referred to an extraordinary amount of debt on the part of Mr. Mahan when she first advised Miss K. Noticed he was paying outgoings by credit card. Mrs. K explained, and that's a reference to what she said in court, not what she said to the claimant earlier in advice. Under an NSMO, the initial maintenance was £0, but depending on whether the order was of an indefinite duration or for a defined term, or by reference to the minority of the child, provided the opportunity to come back to court in the event of a later change in circumstances. Mrs. K had said that would not necessarily be the best outcome for Miss K in circumstances where having to bring Mr. Mahan back to court was not the position she wanted to be in. So that's consistent, that evidence that she gave is consistent with the appellant's case, that from the outset, Mrs. K, Mary K, had been advising the claimant and pushing her in the general direction of do a deal, settle on a clean break basis, and go and start your life again, as I mentioned earlier. And then over the page at paragraph 134, I'm sorry, at the top. It was Mrs. Kay's own evidence, Mary Kay, that the appellant listened to her advice and trusted it. It was very much a team approach. And there's a discussion about what she said was the appellant's wish to be financially independent. And then at paragraph 135, Mary Kay described the settlement as a very good outcome, and she thought at the time that Miss Kay had been very satisfied with her work. Now, the reason I take your lordships to that is because, again, this is about what actual knowledge claimant may or may not have acquired at the end of 2008, beginning of 2009, and whether, and the context. And the context is, she thinks that Mr. Mahan has hidden assets and so on. She tells Mary Kay about that. She receives certain advice. She accepts that advice. She trusts Mary Kay as her lawyer, that her advice that it's not proportionate to look into these things any much more, and that she should get a clean break is proper advice. So that's the appropriate context. Now, the judge then begins to provide his analysis of actual knowledge at the bottom of that page of paragraph 140. I'm satisfied on the evidence, including her own, that Miss Kay had actual trigger knowledge by no later than the end of 2009, and if she didn't have actual knowledge, she should be attributed with constructive knowledge. And then he goes on to say over the page at 141, even if that had not been the case, my finding would have been one of constructive trigger knowledge by no later than the end of 2018. And therefore that the claim was out of time. And at 143, he notes that Miss Kay's evidence was to the effect that she'd never been satisfied with the settlement. She'd always tried to set it aside. Now, pausing there, it is right that Miss Kay's evidence was to the effect that she'd never been satisfied in the general sense, because she wasn't happy with her lot in life. But as we've just looked at, Mrs. Kay, Mary Kay's own evidence, recorded at paragraph 135 on the previous page, was that she thought she was very satisfied. So it's important in my submission to bear in mind the distinction between general dissatisfaction with the outcome and dissatisfaction with the advice. And the judge's reference to always try and set it aside is not, that evidence was not given on the basis of, I've always tried to set it aside because I'm unhappy with the advice I was given. And in order to see that that is the case, I'm afraid I need to take you to the transcript of the appellant's evidence, which is in the December bundle. That's tab 10.
We don't seem to have tabs, can we?
Page 107.
It's page 107. I'm afraid my instructing solicitors were not responsible for these bundles, I don't think, but I'm sorry that you don't have tabs. So, we need to turn, please, to page 137. Now, there's obviously a lot of evidence here. And maybe that my little friend needs to take you to other points as well. But the passage in question really starts, I'm sorry, not at 137, at 136. Apologies. So at 136, at G, after some discussion about the property market diving at the end of 2008, my learned friend asked, so the property market's going downhill, see the way that developed since 2009, discussion about the mortgage payments and so and then he's made payments on the mortgages towards the bottom of some £16,000, concerned about letting Manor Cottage, and so on. And then over the page, my lords, page 137, at B, my learned friend's question is, so this becomes a major concern by the stage, does it not, Miss Kay? The property market's going down, an asset, Manor Cottage, the main source of capital provision for you under the settlement, is becoming less valuable as time passes. And she responds, it was, and talks about some of the detail. And there's then some further discussion about the sale of the property and auctioning it and so on. And then over the page at 138, please, at D. So you're now saying significant change in your own circumstances since the order because of the way in which the property market is going and the effect of the settlement in the light of the declining market. That is the point you're making, is it not? And in answer to that, this case, and I think my point is, if I could find a way to reopen, that would be my goal. And question, that's what you want to do, and she finishes her sentence on that one. And then, at the bottom of that page, learned friend at H asks, so your circumstances by this stage are extremely difficult, as we can all see from that email. Yes, was the response. You maintain the position, did not get a fair deal, is the question. She says, I didn't. And over the page, this is where we get to the point where of the quote that the judge referred to in paragraph 143 in his judgment. My learned friend says, you're now coming at it from a slightly different angle. You're saying, well, because of this change in financial circumstances and the impact upon me of the way events have developed, and his question finishes, you wanted to explore the setting aside. And this is where Miss Kay says, I've always tried to set it aside at every point because I just felt the system was wrong. Learned friend says yes, and she says, I don't know whether that's possible or not. I tried. Now that, my lords, is the proper context for that evidence. She said, I've always tried to set it aside in answering questions about the decline of the property market and the problem with the property and so on. At the end of that passage...
I'm just looking at other bits of the transcript and other bits of the judgment. She's always said from the beginning she thought it was unfair.
Yes. But
she thought it was unfair in October.
My lord, yes.
2008. But she saw him in the Porsche.
But the most critical part of the passage I've just taken your lordships to is what she says immediately after I've always tried to set it aside. I've always tried to set aside at every point because I just felt the system was wrong. And the transcript is replete with, as my lord says, her evidence on this sort of issue, with her saying, the system is wrong, the advice I got was wrong, not I always tried to set it aside because the advice was wrong. She felt, as the result of the advice she was given, there was simply nothing else she could do. She accepted that advice. But what the judge did in this case was particularly on that bit of her evidence, and he mentions it more than once in the judgment, that as a basis for saying that she had the actual knowledge at the end of 2008, or at least in 2009. And going back to his judgments, if the lordships have that in front of you still, paragraph 143, he goes on to say, by June 2009, following the termination of the firm's retainer, after repeated negative advice on that front previously given within a couple of months of the court order embodying it, she was equipped with the level of knowledge identified in Hayward.
Sorry, where are you?
I'm so sorry, my lord. It's paragraph 143 of the judgment.
Oh, yes, I see.
So, my submission is that the judge has made a link between that bit of evidence and having the level of knowledge identified in Hayward, and then goes on to say, at 144, it must by then have been obvious to Miss Kay that on her case in these proceedings something must have gone wrong in the advancement of her ancillary relief claim. And in my submission, that's simply, as I've said already, I think at one point at least, that's simply too high level an analysis. It is not grappling with what the advice originally was and what the later advice post-settlement was, and whether the latter could give any reason to suspect the former. as at least the cause of her situation. The judge then goes on to say, and he at paragraph 144, he makes an assumption that there was, for these purposes, negligence in not securing a term of the settlement that would have enabled her to seek further financial provision. But at paragraph 145, he continues with his analysis at actual knowledge. He says, by the time the firm ceased to act for her in June 2009, she knew enough to cause her to investigate the possibility that lack of recourse to Mr. Mahan may have been attributable to fault on the part of the firm. Using the language in Whitcomb, she had some reason to consider that may have been the case. In my judgment, that is obvious when one considers the position she found herself at the time. And then he goes on to say, allowing for the fact, and this I think I'd already taken your lordships to another part of the judgment where he had recited her evidence on this, but here he appears to find, as a fact, that the early 2008-9 inquiry about revisiting the ancillary relief claim was driven as much, if not more, by her own post-settlement impoverishment than by Mr. Mahan's apparent financial position. She would or should have asked herself, and I think this, in a sense, paraphrases something one of your lordships said earlier, how is it that, with the supposed benefit of legal advice, I found myself in this position? Goes on to say, 146, I accept that Miss K should not be attributed with knowledge in 2009 there was such a thing as an NSMO. Mrs. K accepts she may not refer to one as such, but Miss K did know the settlement gave Mr. Mahan a defence based upon the clean break. The clean break was at odds with any ongoing maintenance in time, whether one initially fixed at zero, but potentially subject to later review, or otherwise. And then at that point, he goes on to deal with my submissions on Whitcomb, which I'll come back to. But, as I say, in my submission, he is giving a very impressionistic analysis and not actually referring to the advice. I've already announced...
Can I just break it down a moment?
Yes.
A while ago, you were referring to the advice which your client got when she went back to Mrs. K.
Yes.
Had she not gone back to Mrs. K, would you have said, or wouldn't you have said, that she had sufficient knowledge?
She didn't have, at that point, actual knowledge in my submission because she had learned about a Porsche that, so far as could be told, he had acquired later, and a company which she knew had been incorporated after the settlement, an insurance policy that was in fact for her benefit anyway. But as I was discussing with my lord earlier, that she did then potentially have constructive knowledge because something had happened that would have made it reasonable for her to go and seek expert advice. Not something that gave her the actual knowledge. So I have to tread a fine line here, but something that gave her something to ask a professional about in the circumstances. She asked the question of Mary Kay.
So regardless of going back to Mary Kay, you say she never had actual knowledge.
My lord, that's right, yes.
I understand that. I see the force of that, given the way that you've described the material fact. But constructive knowledge I've got more difficulty with, because you accept that later on, 2017, 2018, the state of affairs was such, she didn't have any benefit from the settlement and he had lots of money, it seemed. Gave rise to a situation where she might reasonably have been expected to acquire from facts ascertainable by him, ascertainable by the appellant with the help of an appropriate expert. She should have done that in 2018, and you've got your arguments about impecuniosity. But it looks as if there is no difference between 2009 and 2018, so she ought to have reasonably been expected to acquire from expert advice the fact that what had gone wrong was that she hadn't been protected. And the argument then really is that the different thing, she did take reasonable advice by going back to the same solicitors, that was enough. In each case, she would have had constructive knowledge were it not for the application of the proviso, albeit for different reasons in different stages. Is that a fair summary of what you're saying?
It is indeed.
Right.
Yes, I follow. Let me just make it next time clear. So as to the early period, I'm not sure why I'm saying this since it's your case. You say merely knowing that the settlement hasn't turned out well for her didn't provide there's something extra that Lord Nichols had in mind. But there would have been constructive knowledge, but for the fact that she went back to Mrs. K.
My lord, yes, and that one presumes is why the statute cases for both, because in balancing the interests of claimants and defendants, and as it were, not letting claimants get away with saying, well, I just didn't know, it also provides for the constructive knowledge point. And so there will be occasions where, obviously, perhaps it's stating the obvious, and I apologise if it is, but where you don't have actual knowledge, but where the constructive knowledge provisions are engaged sufficiently, because it sets you on a train of inquiry. So you haven't got to the point where you've got the knowledge yet, but if you've gone and seen someone, which you should have done, you get that knowledge. So that's how it, in my submission, works, how the legislation works, and the appellant was in the no actual knowledge, set on the train of inquiry, potential constructive knowledge, but doesn't acquire it because of the proviso territory.
But the thing which gives rise to the constructive knowledge is the realisation that something has gone wrong that needs to be investigated. But the point on which she goes back to Mrs. K is not what has gone wrong, but the specific question, can we set the settlement aside?
Precisely. Yeah.
So she doesn't investigate, she doesn't in fact investigate the thing which needs to be investigated. She only investigates a subset of that.
Yeah. And the reason why, in effect, I have to accept, as it were, that she's at the point of having learned about the portion, the company and so on, of needing to seek expert advice, is because, in fact, when she eventually gets the expert advice of Miss Edmonds, counsel, in 2020, albeit in relation to the much greater accumulation of wealth by that point, Mr. Mahan, it is that which leads to the identification, not just of a causal link of attributability, which is the knowledge that actually matters, but in fact of potential negligence by the respondent.
No, that doesn't matter at all. Potential negligence is out. Subsection 9. What is the fact is something has gone wrong and something could have been done to prevent it.
Yes, my lord. I'm sorry, all I meant by that submission was that Miss Edmonds actually goes further and goes beyond, but in going beyond and saying they might have been negligent, that necessarily includes knowledge of potential attributability.
Something has gone wrong. What's gone wrong is you were badly advised, and the people responsible for that is the solicitor. That's the chain of knowledge of fact.
Yes, and that's all in effect encapsulated by Miss Edmonds saying the real culprit here is Shakespeare.
Yeah.
She said Shakespeare Martineau. That was the new name of it.
So have you taken all reasonable steps to obtain expert advice, in the language of the proviso to subsection 10, if you have only sought advice on a narrower question?
My response, my lord, to that would be, in these circumstances, yes, because it's almost, if I may say so, the other way round. It's the same it's the same other question that she later poses that in fact gives rise to Miss Evans saying they may have been negligent, but which encompasses the knowledge actually required. And the section, so I'm perhaps wrongly, but looking at it the other way round, the section talks about facts ascertainable or observable with the help of expert advice which it's reasonable to seek. So if the necessary consequence of going to see a barrister or another solicitor would be that they would say, well, actually, you need to look at your former solicitors here because they may have put you in this position, to put it that way, then that would give you constructive knowledge unless you could rely on the proviso. But the converse is not true in my submission. It's not that she had a reason to investigate at that point whether or not the settlement was unfair as a result of the act or omission of the respondent. It's just that having made those investigations on the other issue, the new wealth, had she gone to anyone else, she might well have been told what Miss Edmonds eventually told her.
But the problem is, which question should she have asked? Should she have asked, can we reopen it? And she was told no. Should she have asked, what's gone wrong? Why am I in that position?
Well, perhaps we need to look at exactly what she asked. It was effectively, I wanted to reopen it because I felt the system was wrong.
That's one question, but she said in lots of other places, this is unfair.
Yeah.
I haven't got anything out of this, and he's driving around in a Porsche, he's got a company.
Yes. So, in that sense, she did go in the direction that my lord was talking about not just can I reopen it because of these assets, but this is unfair. She did ask a slightly broader question, it seems, but she didn't. I mean, had she asked the question, am I in this position because we didn't explore enough of the options in relation to the ancillary relief proceedings, then arguably she might already have got to actual knowledge by that point.
It wasn't your case, as I understand it, but please tell me if I'm wrong, that the question which she did ask in 2009 should have prompted Mrs. Mary Kay to say either we have been negligent or you'd better investigate whether we've been negligent. That wasn't your case, was it?
Well, actually, that was our case at the preliminary issue trial because that was the basis for the deliberate concealment argument.
Yeah. And
Which the judge rejected.
Indeed. Yes, which we don't pursue an appeal against.
Right. So for the purpose of this appeal, it can't be said that Mrs. Mary Kay should have revealed the possibility of her being negligent.
No. But that is respectfully a separate issue to whether or not my client's entitled to rely on the proviso. Just as in the Gosden and Halliwell Landau case, Mr. Staidlow in that case failed to register a restriction, was quite obviously negligence, and there is some comment in the judgment about the fact that perhaps he ought to have revealed his own negligence. And the claims in that case was found to be reasonable in going back to him for his expert advice on the later situation. So the fact that a lawyer who is the original advisor might well appreciate their own potential negligence is not, in my submission, relevant to whether or not going to seek advice from them is reasonable. And that's, one assumes, because the lay client is not a lawyer, so they don't know.
Well, it might be because the question is whether you've taken all reasonable steps to obtain expert advice, and if you've asked a narrow question and got a narrow answer, that's one thing. But if you've asked a narrow question which ought to have revealed a wider answer, i.e. the answer to your question is no, we can't reopen, but you should also think about negligence, then that would be a different situation. But we're not in that area.
No, but in my submission, she did take reasonable steps, and she went back as the judge, and as I've identified, the judge has recorded that her primary motivation in going back was not, in fact, whether or not she got a good deal, as it were, in the April 2008 settlement, but actually whether or not anything could be done about the apparent new wealth. But in my submission, she did enough in making those inquiries and can rely on the answers she was given to prevent constructive knowledge from arising. Going back to the advice that she was actually given, I've gone through what was said on the 12th of December 2007 meeting. There was a little advice given at the FDA.
FDR.
No, I'm sorry, the FDA. The first hearing in December.
Oh, I see.
My lord. So the defence admitted what was pleaded in the particular claim largely admitted that. So perhaps I ought to take your lordships to this briefly. This is tab 7 in the core bundle, please. Page 102. So, at paragraph 32, prior to entering court for the FDA, Mary Kay suggests the costs of the case are already excessive. The claimant needs to look at the money in the pot right now, and if we're lucky, we may be able to prove that Mr. Mahan has money offshore. So, not closing down that entirely. And then, however, Mary Kay also stated that we should not expect to ever get to the bottom of it, and that digging around so much will not help anyone. And then over the page, at paragraph 34 on page 103, after that hearing, Ms. Kay again spoke to the claimant, stated that once Mr. Mahan had answered the questionnaire, we will then settle and say we do not need to know more information. The claimant indicated she was happy to be directed by Mary Kay as such strategy. Mary Kay also stated the claimant needs to be able to work herself and would feel better not to be reliant on Mr. Mahan. And then at tab 8, at page 126 in the defence. Sorry, I think I may have moments ago said that paragraph 32 was admitted. That was wrong, and I apologise. It wasn't substantially disputed. So at paragraph 13 in the defence, the claimant was required to prove paragraph 32. Although the defence does go on to say, slightly inconsistent with that non-admission, the defendant in any event denies these comments were statements of substantive principle, defined tactics or designed to be binding or persuasive. And then over the page, paragraph 15, in relation to the post-hearing advice, again, it's a slightly equivocal pleading, but the claimant is required to prove, paragraph 34, but even if proved, the defendant avers this was a general observation as to the likely outcome and trajectory of the case, therefore relevant to the issue of breach. So that's the next bit of advice. There was then a letter in 20th of December in which the respondent said that the matter needed settling as soon as possible. And then there was another letter, which is admitted in the defence, which is at, back to tab 7, I'm sorry, page 103. So this is at paragraph 35 in the particulars, where on the 23rd of January 2008, the respondent said, I've also asked Mr. Hobden if he would speak to his client with regard to his family's actions. This is just serving to increase your costs, Helen. My client's former name. The more I see of this case, quite frankly, it does not surprise me the level of costs which have incurred to date. I'm going to try and keep it on track, and so on. She talks at the bottom of that page in the letter about her experience in pensions, and over the page that it says that the letter actually said, it says it's unlikely that you'll be able to pull the wool over my eyes. So, again, another emphasis on costs. And then we get to the period in April 2008, where prior to the FDR, so that what became effectively the final hearing, there was some advice about that at paragraph 37 in the particulars, which is again admitted in the defence. On page 104, another letter was written. There was an argument, I'm paraphrasing, that Mr. Mahan's interest in Wall House, that was the property which had been transferred to his brother, and which the avoidance of disposition order I mentioned earlier was potentially to be sought in relation to. Being transferred to his family is undervalued, but because the claimants had been aware of the transfer and the price, then the argument was impliedly weak. This is where that I mentioned to my lord earlier, the point about the 5-year maintenance order being raised, and this was in the context of the offer that was to be put before the FDR, and that there should be a 50% pension sharing order.
So alternatives to a clean break were canvassed.
Yes.
in terms of what facts she knew. She knew as a fact that there was an argument about transmission and undervalue, that you could get a maintenance order and a 50% sharing order. So the only thing she did not know as a fact, it seems, was that you could get this non-spousal thingy-bob,
Yes.
which would allow you to come back.
But of course, my lord, the avoidance of disposition point in relation to Wall House is not really relevant to what happened later. So later was all about the other wealth that Mr. Mahan accumulated.
No, I understand that, but it does increasingly turn, it looks like, in terms of knowledge of material fact. And certainly, if given what she had, she should then have gone on and taken advice, that she knew a lot of things, a lot of facts about the settlement, that it wasn't just clean break and I wasn't told any other options. It was clean break after being informed of the existence of at least 3 other options relevant to her financial position, but not the NMSO.
My lord, yes, I did mention in my earlier submission that there was other advice given.
Yeah.
And we have to accept that. And the reason I'm taking you to all of this is to give the proper context, because it is a case where other advice is given, and it is said that the other advice is negligent. But for the purposes of Section 48, the critical point is that what then later happens in late 2008, early 2009, my submission doesn't, as against this background, give rise to actual knowledge.
Yeah, but it's important not to run the negligence case, it's important to run the limitation case. And the next paragraph goes on about things like not being advised on the merits and likelihoods of successfully seeking a pension sharing order. If that was the problem, then she knew about that, had everything she needed to know, or at the very least had everything she needed to know and get advice about that. She should have gone to somebody and said, should I have been told more about this pension sharing order that was mentioned but never gone into in detail? That's a very different state of knowledge and affairs than she wasn't told of a nominal spousal maintenance order.
Well, my lord, yes, but the submission there is, why would learning that he has a Porsche and a new company incorporated after the event give rise to a questioning of whether there should have been a pension sharing order? That wouldn't have...
Oh, it's all of it. It's the forensic accountancy evidence and
Yes.
it's the whole of that paragraph, sorry.
Yes. There is, I accepted that earlier, that there was an element of advice. Well, but that's the point. There's no advice given on that. There's no advice given on the forensic accountancy aspect. And the advice about generally investigating him is a bit variable, as we've already seen. So it's Mrs. Mary Kay occasionally says things along the lines of, well, maybe we could investigate a bit further. But she also, in the same breath, as it were, says, but there's not really any point because it's going to be too expensive. And
that's different because we're talking about knowledge. And if she's sitting there thinking, why haven't I got this? And she's thinking to herself, well, I was told I could investigate. Should they have done more to investigate? It may be relevant to 14A10, but when you're looking at the facts, it's not the negligence, was it negligence? It's what she knew.
well, Lord, I understand.
Yeah.
I understand. The response is, I mean, ultimately, this is where we get into not just the facts, but the degree of knowledge required, as we were exploring in relation to Hayward. And it's in a context of, you might be able to do something, but you probably can't within our system. This is where she says, after saying, I always try to set aside the system was wrong. The picture she is being given is, there isn't anything else I can really do here. Maybe there's a theoretical possibility of investigating, but I can't really do it. And as against that factual backdrop, to then become aware of a portion, a company that appear to be new and don't on the face of it appear to really bear any relation to whether he had lots of hidden offshore assets and so on. I mean, the Porsche is clearly not an offshore asset. The new company is clearly not an offshore asset. The link is not sufficiently there in my submission.
It rather suggests, doesn't it, that if your appeal succeeds, then it should be on quite a narrow basis to do with this NSMO,
Yes.
because although you've pleaded the kitchen sink in terms of allegations of negligence, and I don't say that pejoratively because at the start of the case you do, in fact she knew most of the things at an early stage. So claims about hidden assets and so on, which she certainly says she knew about, ought not to go to trial on the merits. And if the appeal succeeds, then quite a lot of your particulars ought to. So if the appeal succeeds on that narrow basis, quite a lot of your particulars ought to go, didn't they?
Well, the particulars were not, and hopefully framed very carefully, were not. She was never told about. There were certain things she was never told about. The NSMO being the most stark example, but they were not. She has no. She was never given advice at all about the possibility of exploring assets, hidden assets. She was given inadequate advice. So
This is not a. You keep going back to she wasn't given advice. What did she know? What material facts did she know? And what would that have required her reasonably to do? And she knew that there was the possibility that he was hiding his assets. She knew there was a possibility of investigating that, but she'd been told it was too expensive.
yes,
And one question she should have gone back and said, well, how expensive? Why didn't you tell me to do this? You know?
well, my lord, I was only responding to my lord's question about the particulars of breach and what type of case might go forward. That's the only reason I went back to breach of duty. I can only say what I said already, really, because the link is not there just because there's a portion accompanied. That's not enough. Then we have the advice at the FDR on the 25th of April that clean break was again advised as being appropriate, and that was accepted in the defence.
Sorry, where's that?
So this is paragraph 41 in the particulars, page 106. So this is the description of what happened at the FDR. Your Lordship will see at 41B the reference to pie in the sky from District Judge Ingram, but which is important in my submission because that again is the context that the appellant is. That's part of her understanding, as it were, that the system is against her, rather than making a later link between the Porsche and the company and maybe something that wasn't done properly, or even if we ignore the point about negligence, just wasn't done by the respondent. So we have the pie in the sky comment there. There's a discussion about what in fact actually happened. And then over the page, at E, page 107.
You just read bottom 106.
Yes, of course. My learned friend asked me to read D. During the course of negotiations outside of court, the claimant informed Miss Kay, Mary Kay, that she believed Mr. Mahan deliberately built up debt whilst hiding assets in order to minimise his assets and reduce any award to or settlement with the claimant. So the appellant had not completely let go of this idea. Over at E, over the page, further negotiations, she enters into the settlement. During the course of the day and prior to agreeing with the settlement, Mary Kay advised the claimant that proving avoidance of disposition in relation to Wall House would be quite difficult. There was a big dispute as to income. She was a strong woman, she could start again, and strongly advised to opt for a clean break. And the defence, so that's effectively the final advice. And the defence at page 129 behind tab 8. At D, so the defence responds with the same lettering. In relation to the part my learned friend just asked me to read out about.
Sorry, which I'm behind. Which page are you in?
I'm sorry, my lord, it's page 130.
Well, thank you very much.
Tab 8, 130. It's the same lettering as the particulars of claim, paragraph 41 we were just looking at. So at D, the learned friend responds to my paragraph 41D. The allegation that the appellant had informed Mary Kay she believed that debt had been deliberately built up and was hiding assets. The response is Mary Kay has no knowledge of this and requires to prove what was said, but is inconsistent with the previous and contrary instruction that Mr. Mahan did not have secret pots of money. And then E is, in my submission, the critical part. So at 41E in the particulars, Roman numerals 1 to 4 set out various points, including at the end, strongly advise the claimant to opt for a clean break. And the response is detailed and gives what the defendant says, respondent says, the context, including negotiations, so on. But if the lordships look at the, I think it's the 9th line, the right-hand side, Mary Kay's advice that the claimant opt for a clean break was not only consistent with her previously discussed and agreed position, but was also an outcome most suited to analysis of this case. And then the point about Mr. Mahan being in debt. So, the point being that the final bit of advice is clean break. Now, why that's said to be the advice is a matter of dispute and would be a matter for trial of the claim as a whole, and whether or not that was negligent, which is not what we're concerned with. But the advice nevertheless was take a clean break. I think we ought to, I'm sorry it's taking a while, but I think, well, in fact, I noticed the time, it's 5 to 1. I was about to take the lordships finally in terms of the evidence, I think, to the detail of the late 2008, early 2009 advice, which we've touched on. But,
Shall we keep going for the moment to see where we get to?
thank you, my lord. So this is in the supplemental bundle. Tab 9. Tab 9, page 18. So this is, I mentioned in opening, it was the 20th of October when the appellant first inquired about abortion and so on. This is an email to Rhea Evans, is the assistant to Mary Kay at Martineau Johnson. So after the first 5 or 6 paragraphs of other matters, there is a paragraph starting, I've also found out. I've also found out he started a separate company on Tuesday after our FDR, after FDR, which he's the MD and is now driving around in a Porsche. Made the Child Support Agency aware of this fact, they're incredibly slow, and so on. And then at the end of that paragraph, again, he appears to be saying one thing to court and you, and doing something completely different. I've also been made aware of an insurance policy in my name that he's not previously declared, to which a note appears to have been placed by someone at the defendant, so what? And then with this plus the information I provided matches, I am minded to reopen the file. But this would be something I could not currently afford on a fee-based deal. Would you, or do you know anyone who would consider this information? And I'd be happy to offer a percentage of a successful claim against it. I'm just pausing there. She's concerned about the Porsche and the new company, but there is the reference there to the information I provided to Manches. And the information I provide to Manches is the Hildebrand bundle. That is about the wider picture. So the inquiry that she makes is, to go back to my lord's earlier questions, is essentially about the new matters, but it does encompass the wider picture. Then at tab 10.
Sorry, we need a page.
Sorry, it's page 19. Page 19, there is a later email. So one can see from the bottom of the page, Miss Evans on 28th of October had emailed back trying to arrange a call between the appellant and Mary Kay. And then towards the top of the page, the next email is clearly after that call, because in the 3rd paragraph, the 11th of November 2008, in the 3rd paragraph, the appellant says, when I had my call with Mary, what a fantastic lady, she was going to forward me a copy of a decision regarding substantial information. It was a case that had been heard where an ex-wife or ex-husband had produced evidence after a final hearing that proved to offer significant information that would have changed the outcome. I appreciate the advice is to leave it, unless I can prove the former. I think that should be former, it's not clear. But she was just going to send me a copy of the wording. That is the relevant passage in that email in my submission. And then the next communication is page 22, my lords, which is the letter of the 17th of November 2008 from a colleague of Mary Kay, a colleague Kate Booth from the same department, at the bottom of page 22. I understand you also spoke to Mary about a recent case which has dealt with matters that had come to light after a consent order was made. I enclose a copy of that case for you. This case confirms the information must be so substantial that had it been available at the time the consent order was made, it would have materially affected the order the judge would have made. The fact that Mr. Mahan has now set up a new business is not in itself reason for a different order to have been made. There are 3 other pages to take your lordships to, if I may.
Yes, do.
Page 24. So we've moved on in time now. So she's had, the appellant has had the copy of the case in November. 20th of March 2009, she emails Mary Kay again on a number of matters. It starts to do with the Newey letter, that's Mr. Mahan's solicitors, but that's, in my submission, not relevant. It really becomes relevant towards the bottom of the page, where under the heading Goals. She says in the 5th line there, remortgage on Manor Cottage, that's the former matrimonial home, in my name. Me to contribute a certain amount, him to contribute the rest as a term basis maintenance payment, as he indicated in his Form E. Not too sure if this is now possible. However, I do believe there have been significant material changes to my circumstances since the order, and maybe this is possible. One can only try. And she goes on to give some reasons over the page, numbered 1 to 5.
I mean, in this message, as in previous ones you've shown us, there's a repeated concern about costs. She's saying she doesn't want to spend a lot of legal costs.
That is a factor.
Which rather confirms, doesn't it, what the solicitors are saying about not wanting to incur all these costs investigating this, that and everything before the settlement is reached.
Yes, cost is certainly an ongoing feature, but in my submission, that's not particularly relevant to the question we're dealing with. It's more relevant to the question of causation. The full trial of this matter as to whether, had she been properly advised, she would have done something different. But it's not, in my submission, relevant to this point, other than as part of one of the factors in the context. And my lord, over the page at 25, after numbered point 5, she says, please be assured I make these remarks in the essence of trying to achieve fairness and compensation. There has been a material change in circumstances since the, I think that should say FDR as noted above, and I would now like a fair deal. Is this possible? And there's, yes, to say a couple more documents. Page 26. Between that email, 20th of March and 26th of March, there has been a meeting, it seems, and at the second paragraph, Miss Evans, but it's Mary Kay's email, but sent by Miss Evans, says to the appellant, to confirm my advice when we attend the office, it's my view we cannot apply for this minute order to be set aside. Unfortunately, we find ourselves in this financial climate, but nonetheless, previous case law, and indeed current case law, since the financial credit crunch would indicate that unless there are serious problems regarding law in the order, than any more than if suddenly house prices soured or soared, I think that should say, then we would be suggesting we go back to give money back. It is not possible now to revisit on the basis the financial climate has changed. And then she says it might be possible to revisit on the basis that he said he would use best endeavours, including the court could not envisage the children would be without a home when this order was made. So the discussion is all about change in financial circumstances. In the preceding email, the appellant does talk about whether or not there's been a fair deal, but the emphasis is on change in financial circumstances. Final 2 pages, page 27, over the page, there is an email here which is not dated on its face, but the parties accept comes in between end of March and the next document, which is the 5th of May, probably towards the end of that period, where she talks about her research into the Red Book, Family Court Practice Book at the library at the bottom of the page and so on. I don't propose to read that out verbatim. She's making the same sorts of points again, and over the page in the 5th paragraph, she refers to listening to Mary Kay at the meeting, and she knew that she said the order was the order. And then finally,
She's also looked into the little red book, Family Court Practice book,
and
at the library.
yes, she'd done some research. She wasn't, as it were, leaving this alone at that point. But also, the focus is all on, really, throughout these communications, can I reopen it on the basis of the new information about the new assets? And the final document is page 29, which is an attendance note, 5th of May 2009 from Mary Kay, recording her conversation with the appellant. In the 2nd paragraph, that she'd been trying to speak to Neil Hobden, is Newey and Co, Mr. Mahan's solicitor, that Mary Kay does not agree with the way Helen thinks we should go forward. Do not believe this is a case appropriate to have a consent order set aside, or indeed apply for leave at a time to set aside or vary. She then says, if I had any doubts, current case law has proven the change in financial circumstances does not mean that the court is going to revisit an order. If he makes an application, bring it back. It's no bad thing, to paraphrase. So essentially, the advice was again in line with that authority that had been provided in November 2008. There's been no material change in circumstances because it's not about pre-existing assets. So that is the advice that is given afterwards, and it is that advice which the respondent said and which the judge found was enough to give rise to actual knowledge. We say it doesn't, and indeed it absolves my client of constructive knowledge.
And that's going to be an immediate moment. In which case, 2 o'clock.
All right,